is Rob Russell with the Wildlife Pro Network. Today's interview was with Tim Sandefur of the Pacific Legal Foundation. Today's date is 20 January 2009. I want to remind everybody you can find us on the web, the Wildlife Pro Network, at www.wildlifepro.net. In a few moments, I'll be joined by Timothy Sandefur of the Pacific Legal Foundation. Although he was not a co-plaintiff in the Merryfield versus Lockyer case, he did carry the sword and fight for not only the rights of wildlife controllers, but the rights of every American citizen. The Pacific Legal Foundation is a nonprofit legal foundation that provides free legal representation to folks like Alan Merrifield of Urban Wildlife Control in California. The Pacific Legal Foundation defends private property rights, economic freedom in courts, seeking to establish important legal precedent that all entrepreneurs and property owners can use to protect themselves against government intrusiveness. Timothy Sandefur is a senior staff attorney at the Pacific Legal Foundation. As the lead attorney in the Economic Liberty Project, he works to protect businesses against abusive government regulation. He also works to prevent the abuse of eminent domain, having litigated important eminent domain cases in California, Missouri, and elsewhere, and having filed briefs in many significant eminent domain cases, including the Kelo versus New London. Mr. Sandefur is a prolific writer. His book, Cornerstone of Liberty, Property Rights in the 21st Century, America, was published by the Cato Institute in 2006, and he has published many scholarly articles on subjects ranging from eminent domain and economic liberty to copyright, evolution, and creationism, and the legal issues of slavery and the Civil War. Mr. Sandefur is a graduate of Chapman University School of Law and Hillsdale College. He's an adjunct scholar with the Cato Institute and has written for many magazines and newspapers, including Liberty, National Review Online, The Humanist, the San Francisco Chronicle Regulation, and the Washington Times. In February 2006, he became one of the youngest lawyers ever featured on the cover of the California Lawyer magazine. He's a frequent guest on radio and television programs, including the Jim Lehrer News Report, CNBC's Street Signs, now with David Brancaccio and C-SPAN's Book TV and elsewhere. Welcome to the program, Mr. Sandefur, and it's an honor for you to take this time and speak with me. You have my utmost respect for the good work that you do, and welcome to the Wildlife Pro Network. In my eyes, you are a true champion, not only for wildlife controllers, but every American and citizen alike. In your own words, what the Merryfield versus Lockyer case means to me as a wildlife control professional?
Sure. The case was a challenge to a California law that required people who don't use pesticides, who use only structural methods to exclude vertebrate pests and the sort of thing that people deal with when they, squirrels and rats and raccoons and that sort of thing. But the law required people who don't use pesticide methods to spend 2 years in training learning how to use and handle pesticides in order to get the kind of license required to engage in this non-pesticide work. And it required people to take an examination, a 200-question multiple-choice test, testing their knowledge of pesticides and insects and things that they don't deal with. In fact, the state provided us with a copy of the exam that Mr. Merrifield would have had to take. And actually, the court has ordered me not to disclose what's on the test, but I can tell you what's not on the test. There's not a single question on there about how to put spikes up to keep pigeons from landing on a building. And yet this is the test that you have to take in order to get a license to put spikes on a building to keep pigeons away. And it gets better because the California law specifically only applied to pigeons, rats, and mice. If you put up spikes on a building to keep pigeons off of it, you needed to go through 2 years of training. If you put the same spikes on the same building to keep seagulls off of it, you didn't need any training at all. You didn't need any license. You could do that, and that was okay. So we filed a lawsuit. Mr. Merryfield was our plaintiff, and we filed a lawsuit suing the state of California to allege that this was unconstitutional because it's arbitrary and unreasonable. And we got the state's expert witness there in deposition, took an oath. I'm taking testimony from him, and I said to him, now this law requires a license if you put spikes to keep pigeons off of a building. He said, yes, that's right. I said, it doesn't require a license if you put the same spikes up to keep seagulls off of the building. He said, yes, that's right. I said, would you call this law irrational? And he said, yes, I would. And the state's lawyer says, can we take a break? So He comes back from the break and proceeds to testify that, and he knows this because he was the leading figure behind this law, that the law was enacted in order to protect the jobs of companies that already had licenses against fair competition from entrepreneurs like Mr. Merryfield, who wanted to compete honestly for the business of using structural methods to keep pests out of buildings. So this is one example of the way that established companies use occupational licensing laws and other kinds of restrictions in order to protect themselves from fair competition. And the person who suffers, well, there's two groups of people who suffer from that sort of thing. The first one is entrepreneurs who only want to earn an honest living for themselves and their families. And the second one, of course, is the consumer who gets less choice and has to pay more for services. And that's what we challenge at Pacific Legal Foundation. We want to establish the legal precedent that says people have the right to earn a living as long as they treat customers fairly, as long as they aren't defrauding people or a danger to the community. They should have the opportunity to go into business for themselves and offer something to customers without having to face these unreasonable restrictions.
Now, I shared the current law in the books with the state of Florida. Similar laws exist in other states like Texas. How are we NUCOs in these states affected now today?
Well, is your question how does this case affect the rights of non-pesticide
exactly
animal control technicians? Well, what this
this
law
was a case that started in California. How does it affect me in Florida? How does it affect the guys in Texas?
Well, unfortunately, it technically doesn't apply in any of those places, but it sets an important legal precedent that says that if the government's going to regulate this industry, it has to do so in a way that's fair both to consumers and to entrepreneurs. It can't establish a licensing restriction that is designed to protect established pest control companies against fair competition. So, unfortunately, what you see a lot of the time is these licensing schemes, on the surface, people say, oh, well, it's to protect the public. We don't want people using dangerous pesticides and things, that sort of thing. But when you look any closer, it turns out that these laws are passed by politically influential pest control companies and trade organizations in order to exclude competition. So, for example, and one of the ways they do this is the example that you showed me before the program, which is the Florida proposition, which says, well, what we're going to do is we're going to take these two trades, non-pest control, wildlife control on one hand, and pesticide-using insect control on the other, and blend the two together and impose these training restrictions on them that are so burdensome that it basically creates a wall that small business owners can't get past. Established companies, they've got the money. They can put people through training regimes. They can ensure that the government does what they want. But newcomers, entrepreneurs who just want to start up a business, they have a very hard time getting past these expensive, time-consuming regulations. So the one upside to the Florida statute that you showed me before the program is that it says that it allows the government to create an alternative certification process for non-pesticide workers, which at least offers a chance that that they won't impose these kinds of unnecessary training requirements on people before they go into business. There was a case, not to go on too long about this, but there was a case about 10 years ago in Southern California involving hair braiders. These people, they just braided hair. They weren't barbers. They just braided people's hair. They used traditional African hair braiding techniques, and they opened a business to offer these services to the public. The California Board of Barbers went down there and said, no, you have to get licenses as barbers. Well, to get a license as a barber, it takes 2 years of training, and you have to learn how to use all sorts of chemicals on hair, which these people didn't use. And you have to learn how to do all sorts of different hairstyles, which these people didn't do. And that's the kind of restriction that gets imposed a lot of the time is the government comes in and says, okay, well, you have to be proficient in all these things that you never do. And so that makes it more expensive and more difficult for you to open up a business that offers one small segment of the work. It's like saying that if you want to go into business as repairing people's roofs, you have to get a license as an architect.